Item 1 of the agenda is consideration of new petitions, and we've got 5 new petitions with us today for consideration, and we'll be taking oral evidence on the first 2 of these. The first is PE1370 by Dr Jim Swire, Professor Robert Black QC, Mr Robert Forrester, Father Patrick Keegans and Mr Iain McKie on behalf of Justice for McGrahy, calling on the Scottish Parliament to urge the Scottish Government to open an independent inquiry into the 2001 Kamp van Zeist conviction of Abdelbaset Ali Mohmed al-Megrahi for the bombing of Pan Am Flight 103 in December 1988. And can I welcome Dr Jim Swire, Robert Forrester, Professor Robert Black, Iain McKie and Father Patrick Keegans to the meeting today. One of you is invited to make an opening statement of no more than 3 minutes on behalf of your group, after which members will have the opportunity to ask questions of all the witnesses. Can I have an indication who's going to speak? Dr Swire. Yes.
Mr Chairman, I assume that all members of the committee have the wording of the petition in front of them, and I think it's very important that we stick closely to that, because 2 objections have already been raised against the matter contained in this petition by the Scottish Government. The first is that they maintain that an inquiry raised as a result of this petition would find that much of the material was beyond the jurisdiction of Scottish law and the remit of the Scottish Government. I think the committee can be convinced fairly readily that this is not in fact the case, because if we centre our attention on the Zeist conviction of al-Megrahi, we see that that in turn depended upon, of course, the police investigation, which was Scottish police forces, on the fatal accident inquiry, which in turn was affected by the early stages of the Scottish police criminal investigation. But I think that those investigating this would also need to examine the conduct of the Crown Office in preparing the prosecution at Zeist. And as we enter the trial court itself, I think that they would need to look at the acquittal of one of the 2 accused Libyans, Mr Fima, and the conviction of al-Megrahi, the rejection of al-Megrahi's first appeal and the way in which that came to be rejected, the Scottish Criminal Case Review Commission's referral of Mr al-Megrahi's case to the Court of Appeal, the dropping of this second appeal, and finally the compassionate release of Mr al-Megrahi by decision of Kenny McCaskill. Each and every one of these matters is within the jurisdiction of Scots law and the remit of the Scottish Government. Now, the second objection that has already been raised against holding such an inquiry by the Scottish Government, the Scottish Justice Secretary made it clear that under the powers devolved to Holyrood, no worthwhile scrutiny could be ordered here because there would be no powers to compel witnesses. Members of the committee, I put it to you again that this is not correct. Under the Inquiries Act of 2005, the Scottish Government does have power to set up an inquiry which could compel witnesses and compel the production of documents and other evidence. The establishment and maintenance of an impartial justice system, I put it to you, is fundamental to the health of any civilised community, and it's JFM's position that the failure to institute an inquiry would perpetuate an indelible stain on the reputation and standing of the Scottish justice system at home and abroad. It is the Scottish Government's responsibility to expunge that stain. After 3 years of close study, the Scottish Criminal Case Review Commission publicly stated that the trial may have been a miscarriage of justice. That massively increased the doubts in the minds of many Scots people, both within and without the legal community. This alone must cast doubt on the Scottish Government's current position, and recent public statements by our First Minister and our Justice Secretary claim that they have no doubts over the validity of the verdict against Mr Megrahi. How can this be? When the SCCRC spent 3 years close examination and came to the conclusion that the verdict might well have been a miscarriage of justice. JFM Committee, that's us, now believe there is a clear mandate for the Scottish Government to establish a Scottish-based judicial inquiry. It is not our position as a group that the verdict against Mr McGrahy was wrong, simply that there are now so many legitimate and accessible doubts about that verdict that it must be examined and that it should be Scotland that examines it. The 270 victims of the Lockerbie atrocity, their family, friends, and above all the Scottish people themselves have a right to demand justice, a right to see justice done, and it is vital that ordinary people who have nothing to do directly with the judicial system shall have confidence in their judicial system, and I put it to the committee that the consequences of this verdict mean that that has undermined their confidence. Thank you.
Thank you very much. Can I open it up to members, please, who wish to ask questions? Could you indicate? Bill, followed by Jamie.
Thanks very much, Convener, and good afternoon, gentlemen. Welcome to the Public Petitions Committee. Just to play devil's advocate, if I may. Given that, as you stated, Dr Swire, that Mr McCaskill, on behalf of the Scottish Government, has stated on the record that the Government does not question the initial verdict or conviction of Mr al-Megrahi in January 2001, nor the appeal against conviction being refused on 23rd January 2002, what likelihood do you think there is of the Government changing its position and acceding to the requests made in the petition, given that it's a very definite statement from Mr McCaskill? And whatever one of the panel or all of the panel, would you like to respond to that question?
Thank you for that question, Mr Butler. I think the problem here is that the substance underlying the position of the current Scottish Government does not seem to be secure. In particular, both Professor Black and myself, at the beginning of the trial, speaking for myself, I expected to see two of the murderers of my daughter brought to justice. By what I heard in that court, I became gradually convinced that those two men had had nothing to do with it, and that an alternative way in which it might have been done seemed much more likely. Professor Black, as I understand it, came to the conclusion that the procedures and what he heard in that court in themselves were sufficient to mean that the verdict should never have been passed under Scottish law. And you will notice that we're avoiding discussing materials that have come to the surface since the original verdict was reached, because what was heard in the court was so compromised, the amateur thought and the professional thought. So Professor Black, there's no getting away from it, is a emeritus professor of Scots law. And on the basis of Scots law, I don't know whether he would like to speak himself, but he believes that this verdict should not have been reached.
On that point, Professor Black, would you like to say something about what Dr Swire described as the procedures in and around the trial and your concerns regarding same?
Yes. Part of the problem was that there was no jury at Zeist. Had there been a jury in the Scottish court at Zeist, that jury would have been given the standard instructions that are given by any Scottish judge to any Scottish jury. Those instructions cover such aspects as reasonable doubt, the assessment of evidence, the linkages that can be made between various chapters of evidence, and the requirement of corroboration. Because there was no jury at Zeist, no such instructions were given by the presiding judges to themselves. And it is for that reason that it is my firm belief, and I may say the belief of many other reputable lawyers, You have, I think, before you a statement from perhaps the most experienced criminal court solicitor in Scotland over the past 25 years, Mr. Len Murray. Now, he too cannot understand how the verdict was reached on the evidence that was led. It is as serious and as plain as that.
Could you say, if I may, Convener, could you say a little more, Professor Black, about, you talked about the assessment of evidence and the linkages that would normally be pointed out to a jury. Do you think that those presiding didn't properly assess the evidence and didn't properly make the correct linkages? And if that's the case, could you perhaps give us perhaps one or two specific indications of your opinion as regards those points?
Yes, certainly. Mr. McGrahy could not have been convicted, and this is accepted by the judges and indeed by the prosecution at the trial, had the judges at Zeist not held that they were satisfied that he was the person who, on the island of Malta, bought certain clothing that surrounded the bomb in the suitcase that subsequently led to the destruction of Pan Am 103. This was an absolutely crucial stage in the finding of guilty. Now, the evidence relating to whether the purchaser of those clothes was Mr. McGrahy was as follows. The shopkeeper gave evidence at Zeist, and the most that he would say, and the most that he had ever said in any statement to the police, or indeed at line-up, an identification parade held before the Zeist trial, was that Abdelbaset McGrahy resembled a lot the person who had bought the clothes. But he had also said in his first statement to the police that the person who bought the clothes in his shop was more than 6 feet tall and that he was over 50 years of age. At the relevant time, November or December 1988, Abdelbaset McGrahy was 38 years old, and Abdelbaset McGrahy then, and I think now, is 5'8" tall. Nevertheless, the Scottish judges at Zeist held that what had been given by Mr. Gauci in his evidence was a positive identification of Abdelbaset McGrahy. The second question was, when were the clothes purchased? There were two possible days, the 7th of December 1988 or the 23rd of November 1988. And the reason why it was narrowed down to these 2 days was because of international football matches that were being broadcast on Maltese television. The first leg of the relevant match was on the 23rd of November. The second leg was on the 7th of December. And Mr. Gauci, the shopkeeper, was clear that it was one or other of those days. It was one of the days when the match was being televised, but he could not remember which one. The question then arose, was it possible to narrow down? Because Mr. McGrahy was on Malta on the second of those dates, the 7th of December. He was not on Malta on the 23rd of November. What evidence was led to try to narrow down the date? Meteorological evidence was led. Because when the clothes were bought in the shop in Malta, whoever bought them went out to get a taxi because he'd bought quite a lot. It was raining to such an extent that he went back into the shop and bought an umbrella to protect himself from the rain while he went in search of a taxi. Now, the meteorological evidence that was led at Zeist was to the effect that it rained considerably and heavily on the 23rd of November. But on the 7th of December, there was no rain in Sliema, the site of the shop. or if there had been any rain, it was only a few drops which would not have been sufficient to wet the pavement. That